What do you do when you're falsely accused of domestic violence? At Kersey Law, we handle a lot of domestic violence cases, and a lot of our potential new clients will complain saying, hey, I'm being falsely accused of domestic violence and there's no evidence against me. And what they mean by that is there are no witnesses, no videos, no photographs, no other physical evidence, and it's just her word against his. So it ends up being the classic he said, she said situation, and it's insanely frustrating. So I have to politely educate these individuals and let them know that, hey, her word is evidence. Let's just say the case were to go to trial. The jury would receive an instruction that the testimony from one witness is sufficient to establish a fact. And so what that means is there's not a need for independent evidence. Her statement is evidence and it would be enough to convict you. So for an example, let's just take a couple, Dan and Victoria. They've been having problems lately, but they decide to go out for a night on the town to have a good time. And so they've both been having drinks, and for the most part, it is a good time until the ride home. So they hop into an Uber because they're not drinking and driving. So an argument starts. It's all about Dan liking pics on IG and talking to other girls. The argument spills from the Uber into the apartment. They're yelling back and forth, and at a certain point, Victoria wants to see Dan's phone. She demands to see his phone, and as soon as she opens up the phone, she sees more liked pics on Instagram and texts from other girls. And she instantly goes into a rage and basically starts assaulting Dan. And so Dan doesn't want to get physical with her, but he's also not wanting to get beat up. So at a certain point, he goes towards her, grabs her by the wrist, and kind of pins her against the wall, demanding that she stop hitting him. She calms down for a moment, and then he lets up his grip. But then she instantly starts up again, hitting him, calling him a liar and a cheater. So Dan then grabs her and kind of throws her to the side, and she ends up hitting against the wall. And he's like, I'm out of here, I'm leaving. So just as Dan is about to leave, because this commotion has been going on for some time now, just as he's about to leave, police start to roll up. Dan has no interest in talking to the police. He just wants to get out of there. The police say, hey, we're here responding to a call about a disturbance. Can we talk to you for a moment? And Dan's just like, hey, I don't have anything to say. I'm just leaving. And the police say, hey, hold up a minute. We want to talk to you. And Dan's like, hey, I've got nothing to say. So one of the officers sticks with Dan. The other one goes inside the house to speak to Victoria. The officer that's outside with Dan is just saying, hey, we just want to hear your side of the story. But Dan's been watching my YouTube videos and knows not to give any statements to the police. Moments later, the other officer who was talking to Victoria comes outside and says, hey, I'm sorry, Dan, we're gonna have to arrest you for felony domestic violence. Dan is completely startled by this, but he doesn't resist. He gets arrested and taken into custody. An overnight stay in jail was one of the worst experiences Dan has ever gone through, but he later bails out. Dan immediately calls a lawyer trying to figure out what his rights are and what he can do about this situation. And it's insanely frustrating because, again, at the end of the day, there is no physical evidence. It's just a he said, she said situation. But in Dan's mind, he's already losing. He actually got arrested for felony domestic violence, and now he's facing charges in criminal court. So what is he supposed to do? Well, if I were sitting down with Dan in this situation, I would let him know that, hey, there is hope. One thing that's important to know is where you stand relative to the government when you're charged with a crime. It's the people of the state of California versus you. So it's not the alleged victim. So in this case, it's not Victoria versus Dan. It's the people of the state of California versus Dan. And it's important to understand that the people of the state of California are the ones with the burden of proof. So Dan doesn't have to prove anything at all. And that's important to recognize. It's the people, it's the DA that has to prove their case beyond a reasonable doubt if this were to go to trial. So since the DA has the burden of proof, they're going to be the ones that provide the evidence initially. And this is called the discovery process. It's going to be the police reports, photographs, videos, witness statements, all the evidence that the DA believes demonstrates the defendant's guilt. So in this situation, our team goes through the discovery initially. We have in mind what Dan has already told us about the situation because he's already going to have given us his version of the events. So as we're looking through the reports, we're making mental notes and physical notes about what the discovery shows. And we're highlighting portions and seeing where we're going to have follow-up questions for Dan when we go through the discovery together. And remember, in this situation, it is the classic he said, she said, so there are no independent witnesses, there are no photographs, There are no videos. It's just Victoria's word alone. So after we've reviewed the discovery internally, we're then going to schedule a meeting where we meet with Dan to review the discovery together. And this is a very important process because we're going to separate the truth from the lies. So as we go through the discovery, Dan's going to be able to point out the lies, the misstatements, the inconsistencies, and the omissions, and that's what's going to help us as part of our major defense strategy. And one of the things that's important in this process is not just looking at the police reports, but we're also going to be able to see the video footage of Victoria's statement. Because remember, officers have their body-worn cameras, so as they're interviewing her, their interview is being recorded. And so it's important because it's one thing to see a police statement, which is basically his report based on the notes he took from the conversation. It's another thing to see a person on camera, be able to assess their body language. How do they respond to certain questions? Do they seem dodgy? Are they forthcoming? Do they appear to be open and honest, or do they seem shady? All these things are going to matter. So watching the body-worn camera videos is a very important piece of the discovery review. So after we reviewed the discovery with Dan and gotten his take on the evidence, then we're going to start doing our own investigation. Defense investigation is vital to defending a case. Because think about it, the police had enough information to be satisfied that a crime was committed and you committed the crime, and that's why they arrested you. And then the DA picked up the file from the police, they reviewed it and decided, hey, I have enough here that I can prove this case beyond a reasonable doubt if it went in front of a jury. So at this point, the police and the DA are in the process of building a case that's going to lead to your conviction. So it's very important that we as the defense do our investigation in order to put you in the best position to clear your name. So what we're doing is collecting our own defense evidence. Let's just say, as an example, Victoria showed up at Dan's job a couple weeks ago. She was yelling and being belligerent and causing a scene, and it got so bad that Dan's manager had to call security to have her escorted out. So we would want to get a statement from Dan's manager talking about what happened. Let's say on another occasion when Dan and Victoria were about to go out and they had a mutual friend at the house, they're all pre-gaming and having a good time when Victoria flips out and slaps Dan in the face over a comment about another girl. We'd have our investigator interview the mutual friend who can say that he witnessed Victoria slap Dan out of nowhere. And this is going to be really important because Victoria, in her statement to the police, made herself out to basically be a saint. She did nothing wrong in this situation, and Dan had just flipped out and physically assaulted her. But we know, because Dan told us, that if it wasn't for her actually initiating the physical contact first, then he never would have put hands on her. So by being able to demonstrate her erratic, belligerent behavior at the job, and then just out of nowhere physically assaulting Dan on another occasion, we're able to paint a more accurate picture of who Victoria is. Another piece of the defense investigation might be going back to the scene and taking pictures or shooting video, basically doing anything that we need to in order to paint a more accurate picture of what actually happened. Another vital element of defending a he said, she said case is actually getting to know you. Now, this might come off as a surprise to you, but we at Kersey Law, we find it vitally important to get to know more about who you are as a person. We want to know, what is your highest level of education? Did you graduate from high school? Did you get a college degree? Do you have an advanced degree? Do you have some sort of trade certificate? What's your work history been like? Have you been at the same job for over 10 years? It would be favorable information that you were Employee of the Year for 2 years straight at your office. Are you the primary caretaker for anybody? It'd be very important to know that your mother suffers from Alzheimer's and dementia and you're her primary caretaker and nobody else can help. If you have children, have any of them achieved any noteworthy success? You have a son who's a soccer star and you've been backing him since he was 6 years old and now you're his high school head coach. We're going to be gathering all kinds of letters of support from friends, family members, coworkers, people who can say wonderful things about you. Just remember, the incident that led to your arrest might have been a 10-minute event in your life. Just 10 minutes. For some perspective, if you're 35 years old, you've been an adult for 17 years. And 17 years is almost 9 million minutes. So for 9 million minutes, you've been a law-abiding, upstanding citizen, and just this mere 10 minutes of your life, you've had this incident take place. So it's really important to be able to tell the DA who you really are. The only thing the DA knows about you is what's in those police reports, and I can guarantee you that's not doing you any favors at all. So getting to know you better is a vital step in defending one of these cases. So what we do with all this information is we package it all up and get it over to the DA. And depending on the strength of the defense, because not all defenses are the same, that's going to determine what we're asking for. We might be asking for a straight up dismissal of the charge, or we could just be asking for a more favorable outcome. If they want to have you plead guilty to a felony, we might be able to negotiate that that felony gets reduced to a misdemeanor. Or maybe that the felony gets reduced to a misdemeanor after 12 to 18 months. Or maybe the felony gets dismissed after 12 to 18 months. There's a whole range of possibilities, but where we ultimately land is going to be determined by the facts and circumstances of each particular case. So again, if we feel very strongly about the case and we feel like the DA is not going to be able to prove the case, then that's something that we're going to communicate to them. No DA wants to put a case in front of a jury and end up with a not guilty verdict. So if we can show them information as to why this case will end up with a not guilty verdict, because again, remember, they've only gotten one side of the story. All they have is what they got from Victoria. But if we're able to present Dan's side of the story and show that it's going to be an outright defense and they're not going to be successful at trial, then that's going to lead to them possibly dismissing the case. But again, if we fall short of that, then maybe the victory is having that felony reduced to a misdemeanor or having that felony dismissed after a certain amount of time. However, in some cases, we just cannot reach an agreement. And if the defense and the DA can't reach an agreement, then those are the cases that have to go to trial. But keep in mind that less than 5% of cases go to trial. So the chances of your case going to trial are not very high. But if the case does go to trial, then all that work we did before, reviewing the discovery together, forming our defense strategy, doing our defense investigation, getting to know you better, are all going to be useful as part of our trial strategy. One of the biggest weapons we have as defense attorneys is the ability to cross-examine any witnesses. And so going back to our example, we're able to use the information that Dan provided us in order to point out the lies, the misrepresentations, the omissions, and the exaggerations. Because again, it's one thing for Victoria to be in a calm environment, talking to the police, talking to DA investigators who are just accepting everything that she has to say. It's another thing when you're in a courtroom and you're battling against an experienced and seasoned defense attorney who's calling you out on your BS. We'll be able to use all the information that we gathered to precisely attack Victoria's credibility and point out the lies that she's told. Think of how powerful it would end up being on cross-examination, where we point out that she never told the police that she actually hit Dan multiple times before he actually grabbed her. The jury would actually probably be offended that she left out a major portion of what kicked off this incident. One of the other things to keep in mind is that Dan himself is going to have the opportunity to say his piece. He'll be able to take the stand and testify as to what actually happened. And remember, in the end, it's the DA that has the burden of proof, not the other way around. Being armed with all this information, we're able to roll out a solid trial strategy, but make no mistake about it, trial is extremely stressful. The stakes are high, and realistically, if you can avoid it by having your attorney be able to negotiate a dismissal or negotiate a better deal given the circumstances, then that's going to be a much better option. But it's nice to know that if you had to go to trial, your lawyer put the work in, they did the defense investigation, they know the ins and outs of the facts of the case, and are going to be able to put on a great defense. Facing criminal charges is one of the most stressful things you could ever have to deal with in your life. But it's good to know that if you have a solid team in your corner, then you have a fighting chance at success. I know I said a lot, so if you have any questions, leave them in the comments below. YouTube thinks you'll like this video, so why don't you give it a click next and prove them right. Until next time, peace.